thought here. I'll probably let the plaintiff party start.
I mean, we have all the evidence. We're ready to go to trial. We have a document that was signed September 8th stating my client got a recharge of his pacemaker, stating the type of pacemaker, saying that the taser shorted out the pacemaker, causing it to need a replacement batteries. I have that file in my jacket right here.
Okay. So my question would be there, on the record is, what exactly does that have to do with anything in this case?
What the damages that were caused due to the taser. It's actually very important to the case because my client had suffered damages and had to be seen at pillbox.
Okay, so if we prove that your client, the tase was warranted, do you think that the fact that his taser was recharged is going to hold up in a court of law?
Go ahead and prove that was warranted.
Well, I mean, the burden of proof is on you, but I'm saying if you play what basically just in non-legal and shooting the breeze terms, if you play stupid games, you win stupid prizes. If I stand up and make a nasty comment about your wife, it warrants getting punched in the face, correct?
But there was no nasty comment.
Now, let me ask this. How long have you been in possession of this said document?
I've been in possession since September 8th when I sat down with my client.
Okay. When was this case? What day was this case filed?
After September 8th. Hold on. Hold on.
I believe it's filed same day.
Yeah. So the case was filed at later in the evening, and my document was made at 7 hours before that.
At what point were you going to introduce this to the courts?
During the trial. I made Attorney General aware that I had pacemaker documents.
That form should have been submitted with the filing itself, per legal statutes. But continue on, gentlemen.
Mm-hmm.
Right. Well, with that being said, the district attorney office hereby submits the motion to seek exclusion of these medical documentations since they were not filed the same day.
Okay. We can take a look at the submissions here shortly. If you want to place that in the email to Judge.
Absolutely. Oh, you mean his motion? Oh, okay, gotcha. Sorry.
Both motions.
Okay. I believe I've placed it in
Nah, you broke up there.
The motion in Limine is in clerk's emails.
I just forwarded CC the judge.
Okay.
Let's see. And just for opposing counsel to know, because I think it's fair and we're gentlemen and we're both members of the bar. The reason our primary concern is that these untimely filed medical documents, if received, we can't really authenticate or verify them. So there's really no way to prove that they haven't been altered or modified since the day the document was drafted.
How can you not?
Well, what we're saying is, I'm not accusing you or your client, but I'm saying these documents, if not filed, it's easy. Just as you were able to draft that document and submit it today, I could also go get a document about the taser that was used, explicitly stating that these were tested on pacemaker subjects, and they do in fact not interfere. Obviously, that's not the case, and we didn't do that because it wasn't something that we sought out. I'm just explaining to you as a courtesy why we're filing the motion to exclude this document.
And I'm explaining to you as a courtesy, a trained medical professional who's went to school for medical practices for multiple years, and 2 of them signed the document stating this.
Do you
It
have
was
the
written
current
by them.
document?
Yeah, I
with
can hand
you
it
that
over
I
to
can
you right
review?
now. Yep.
If you get a hand,
You
how many
might have
copies do you
to.
currently have?
I might have
I
to move
currently
out.
just have 1. I could potentially go get some more. But here.
We're gonna need to see the copy of that.
Yeah,
It's-
yeah, we're all, yeah. Okay, I'm sure you heard
You
that.
just pass it around. We can make some more later. My bad.
Yeah.
Just
Is it
trying to-
okay if we just stand up, because we're probably not going to be able to stay seated?
This fucking chair.
Yeah.
okay, so there's. Hold on here.
Mr. Jack Jackson's also in the city right now, so he can confirm that.
I'd like to know if he was a patient, or if this was just like a one time. He went down there and popped by and said, "Hey, by the way, the taser caused my accident." You know what I mean? Like, is he
Right,
is,
and
is he a
that's all
patient, or
that.
is he just like a, you know?
And that's what I mean by authentic. So the 4 legal grounds that we filed this motion in, one of those is authentication and integrity. So if we don't have proof, let's say that we do have proof. Let's say that Mr. Slick Randall is a common patient of Pillbox for this specific issue. Boom, that's your smoking gun. There's your integrity. There's your authentication. However, if this is just a one-time issue, what it looks like to opposing counsel is that you guys just went down there and said, "Hey, I'm in a little bit of a legal pickle. I'm trying to get some compensation. We're really trying to stick it to the cops here. So if you could please sign this documentation stating that Mr. Slick Randall has this issue." It really doesn't look good.
Out of curiosity, what legal pickle would my client have been in? He's the one suing. He has nothing against him. So
Now let me interrupt this. That documentation is not going to be allowed in this courtroom. What that shows is that was a report written as a incident. That's not any official documentation. That's not a letter from the hospital on an official letterhead. That's just anybody can hop in and write that, hey, I was the attending physician. My name is Dr. Jack Johnson. There's at the top of your document, it says that you're currently editing the document. That can't be used as a legal submission in the court of law.
okay.
So after reviewing that, I have no issue signing the motion to dismiss the medical document itself.
So all right, we'll file a motion to dismiss the whole case then.
Okay, well, what about our countersuit, Judge?
At that point, okay, so if now all of a sudden you're looking to dismiss the entire case, correct? Okay, so you can drop the case, that's fine. However, if the defendant, since they're trying to countersue, they have every right to open up another case
That's fine.
to establish the lawsuit against you guys.
Judge, and I don't mean to interrupt you, Your Honor. I just want to state that I actually cannot do that unless the state decides that's what they want to do. So I'm not going to speak for the state. If they decide that no further action is required, then I'm comfortable with that. However, if they do, as their legal counsel, they do advise me that they want to move forward with the countersuit, I do have a legal obligation to pursue that. And as my professional peer, I just want to let you know that, that's completely up to my client.
Correct.
So
I'll let you speak with your client more. Just in the event that this does get bumped into a lawsuit now, what is everybody's availability looking like here?
I'm open.
Just on a proactive measure.
I'm wide open myself.
as long as there's a heads up, I mean, I can be there as long as it's not on a Wednesday or a Sunday. So whatever is the most convenient time for opposing.
Okay. Mr. Mancini?
I'm actually gonna be out of office. I spoke to Peter Sharwoodian. He said he could step in. I don't know his availability.
Okay. Well, let's see on if this does take the next step. But as of right now, we'll officially dismiss this case and then we'll go from there.
Sounds good.
All right.
Thank you,
you,
Mr.
Judge.
Mancini.
Thank you, gentlemen.
Thank you, guys.
All right.
Here's this. Because I have business cards and I don't want to hand somebody that instead of my business card.
All right. You have a good day. Oh, that went well.